Today's guest is Jamie Sternberg. She's a trademark, copyright, domain name attorney at Saunders and Silverstein LLP in Amesbury, Mass. Thanks for coming.
You're welcome. Thanks for having me.
So I have a few questions here, and I'm sure we'll get into a few other things also. But what types of things does your practice do for business owners?
Sure. We focus on trademarks, copyrights, domain names, and software licensing. And we're a 7-attorney law firm up in Amesbury, Massachusetts. I'm working remotely from Connecticut. And we help our clients protect their most important assets, which are their brand names, logos, slogans, as well as their works of art, works of authorship, and works of music.
Okay. Oh, interesting.
Yeah. So we help clients conduct trademark clearance searches for the marks that they want to register and use. And we also help navigate the federal trademark registration process. And we can do state registrations as well. We help clients navigate the copyright registration process. And while businesses can do trademark searches on their own using Google or the U.S. Patent and Trademark Office website, I think it's helpful to have an attorney to help interpret those results of the searches, as well as make sure all your bases are covered in the searches, because trademark rights accrue based on use. And so you want to make sure that you're capturing all trademarks that could be in use as well as registered. And you're not going to get that just from the U.S. Patent and Trademark Office website, and possibly not just from a brief Google search. We can also offer options in terms of searching logos as well, because that's quite difficult to do on your own.
Right.
Yeah. And then navigating the federal trademark registration process. While, of course, businesses can file on their own, having a trademark attorney is helpful, because we can help you craft goods and services for your application to make sure that you're covering all the services and goods that you may be offering in connection with a trademark. And you want to make it as broad as possible.
Right.
You want to make sure you're in all the classes that you need to be in, the classes of goods and services. There's 45 different classes of goods and services that you
405?
No, 45
Okay,
that you have to pick when you're registering. And then as well, you have to file a specimen of use to show that you're using the trademark before it registers. And so an attorney can help pick the most appropriate specimen of use to file, which businesses may find it difficult to do that on their own.
I don't know if "may" is the right word. It definitely sounds like have problems doing that on their own.
And also, if we do the search before we file, we can know what other potential conflicts are out there, and when filing the application, be able to file it in such a way as to avoid those conflicting marks being cited by the U.S. Patent and Trademark Office. Okay. So just knowing those nuances, it's helpful to have an attorney.
Yeah.
And if you're filing a copyright application for something that you've never filed before, the copyright application process can actually be quite complex if you've never sort of gone through it. So it is helpful to have an attorney for that as well. And we also my law firm enforces trademarks and copyrights against infringement. We also help you do trademark watches. We send out demand letters. And if a business receives a cease and desist letter, we can help defend a business's rights and help resolve the issue before it gets too far in court or even gets to court.
Okay.
And we also help with domain name enforcement, as well as trademark infringement issues over social media platforms.
Okay. So software, you mentioned. Tell me a little bit about that. That was something that I wasn't expecting.
Yeah, I mean, I personally don't do a lot of that. My colleague Matt Saunders does a lot of that, so I wanted to make sure I mentioned that we do offer those services.
So what I have here is, this is maybe not the best way to word this, but why is IP law important? Why would people need to? It seems like a big effort to go to do this. Why is that important?
So let me first introduce this by talking about the different areas of IP law, and then I can talk about why it's important to sort of identify it and register it. Okay. So intellectual property law covers patents, copyrights, trademarks, and trade secrets. And patent law covers inventions, business methods and, non-functional product designs, things of that nature. Copyrights covers works of authorship, works of art, and sound recordings and musical works, things of that nature. Trademarks covers logos, slogans, brand names, product design, product packaging, trade dress, and other things like colors, sounds, and smells can also be trademarked.
Really?
Yeah.
That's like colors?
Yes.
I mean, I
Like
guess
the
it would
pink,
be...
the pink color of insulation
Okay.
is the famous example.
Okay. Really, nobody else can use that particular color?
No,
in their
because
insulation?
the color pink cannot be, it's not necessary for
Okay,
insulation.
right.
And so
Right.
everyone knows
Yeah.
that the source of pink insulation
Because
is...
that's gotta be the best,
I
right? 'Cause
can't
you
remember the
see it
name
all
of
over
that
the-
source right now,
Right.
but it is a registered trademark.
That's really interesting. Yeah, I would never think of that.
Yeah.
But of course, right, it doesn't have, it doesn't
doesn't-
have to be pink.
Right.
That's interesting. Sorry, I don't mean to
And
interrupt you,
for
guys.
example, another example is the soles, the red soles of Christian Louboutin shoes.
Okay. Oh, right. Right. Oh,
Yeah.
again, that's something that you don't think of.
Right.
That, yeah,
But when you see
What
those
it is.
shoes
right.
walking down the street and you see someone that has red
Right.
soles, those are Christian Louboutin shoes.
Right. Yeah, that's the thing, is that's something that even as a business person, I don't even think of a lot of
Right.
the time, is that it's more than just a logo.
Right.
Right, it smells and colors
Because
and all that.
yeah, when you see that color, you know.
Well, that's the thing too. What's interesting to that point is what I do is people think that a brand is your logo, but it's not. A brand is what's in your mind,
Right.
It's all the stuff around that business that identifies that business. But yeah, sorry. Go ahead.
Sure. So just as an example, if you invent something like a mobile device, you can patent the invention, you can trademark the name of it, and you can copyright, for example, the advertising materials that you use in connection with it.
Okay.
And so why is IP law important? So it's important for companies to identify the intellectual property assets that they have so that they can be properly protected, registered, policed, and so forth. So patents, copyrights, and trademarks can be registered. Trademarks and copyrights are also protected by what's called unregistered common law rights.
Okay. Right.
And you can also protect inventions and other kind of technology under trade secret law without registering them. And I forgot to mention earlier that trade secret law covers confidential company secrets they don't want to become public. And
Like a KFC recipe.
Exactly.
Coca-Cola recipe.
And those are things that, like, if you were to go through the patent process for an invention,
Right.
your technology would then become
Right.
public. And so if a company doesn't want that to happen, they can protect it under trade secret law.
Okay, interesting. It's like a
Yeah.
black box.
Right. And there's certain measures that you need to take in order to have it protected by trade secrets, like having confidentiality agreements in place and non-disclosure agreements.
It's so, it's so complex.
Right.
There's a lot
This
going on.
is why you need to hire a trademark
Yeah,
or an
seriously.
IP attorney for
Yeah,
these different
seriously.
things.
So, at what point should somebody contact an IP attorney?
Well, so before I get to that,
Okay, sorry, go ahead.
Yeah, so just talking again about like why is IP law important? And there's sort of those two questions sort of tie together.
Okay.
You can't, so say you have a work of authorship or a work of art that's like crucial to your business. You probably want to seek protection and talk to a copyright attorney early on, because you won't be able to enforce that copyrighted work in court before you get a registration for it. There is a Supreme Court decision that just came out this year on that. And so while copyright in a work of art accrues based just on creation of the work, you can send a demand letter for infringement, but you can't take it any further than that. You wouldn't be able to take it to court
Okay.
with a claim of copyright infringement without getting a
It's
copyright
kind of just
registration.
a bluff is the best you can do.
Exactly.
Okay.
Which is basically how I defend those.
Okay.
When we get letters like that, you have to have the registration. And now there's a
Right.
Supreme Court decision based just on that issue.
Right.
Before it was, you could have an application pending with the Copyright Office, and now
Okay.
you actually need the registration.
So done and done.
Yeah.
Okay.
So you want to do that early on, and then it's important to get a trademark registration, and to do that early on as well. There's several benefits to trademark registration. Well, you do have your common law rights based on use. Once someone starts using a mark, as soon as you start using it, you're accruing common law rights, but it's geographically limited.
Okay.
And if you need to enforce your mark, it's going to be challenging. It may be challenging to prove your common law rights, and expensive as well.
Okay.
Whereas if you just, while there is an upfront cost to registration, you're going to save a lot of money potentially if you have to enforce that mark later on in litigation.
Okay.
So some of the benefits of trademark registration is that it provides a legal presumption and a public record that you own the mark,
Okay.
as well as being able to be in the database for the U.S. Patent and Trademark Office, so that when other companies are doing their searches, when they're picking new product names or brand names, they can see that you already have a registration or an application on file.
Okay.
The USPTO, which is the U.S. Patent and Trademark Office, will cite your application or registration against a later filed one if it's confusingly similar. So you can get those knocked out and prevent others from using marks that are the same or similar to yours for the same or related goods and services. You can register a mark with U.S. Customs and Border Control.
So why would you do that?
To prevent importation of counterfeit
so you
goods.
Stop it at the. That's interesting.
Yeah, to stop it at the border, but you need that U.S. Trademark registration
And
to
so
do
that
that.
would. It seems to me that would be very hard. Even if you had that registered with them, it would be very hard for them to catch that stuff as it was.
Well, you
coming.
have to, so along with that, if you are going to go through that registration process with customs, then you have to really sort of implement training programs where you go visit the major ports of entry and sort of train the officials on how to identify
Okay.
products that you think are going to be infringing products
Gotcha.
that you think are going to be imported. And it's, again, less expensive in litigation. If you have the registration, you have a presumption of that you can use a mark nationwide if you have the registration. And as well, you can use the R in a circle symbol with your
Okay.
with your registration, which is really important. You can use the TM or SM symbol, but not the R in a circle until you have a registration.
Okay.
And if you're planning to file outside of the U.S., you can use the U.S. trademark registration as a basis for registration in other
Okay.
countries.
Does it make it easier if you have that?
It does make it easier. It gives you more options on filing.
Okay.
If you file within 6 months of your filing date in the U.S., you get that priority filing date.
Okay.
So you can go 6 months back, and then any application, say, filed in Canada within that time, you would still have the earlier date.
Okay.
So,
Okay.
yep. And then another benefit, another reason why IP laws are important is you can monetize intellectual property assets by assigning them or licensing them.
That's interesting, right?
Yeah.
Yeah. Again, a lot of times, I mean, people. It's not just about you. That's the thing that I feel like a lot of people, probably not this audience, but it's just something interesting to think about.
Right.
It's just like a thought exercise of, even though you say you invented something, you don't necessarily have to be the person to use it.
Right.
There's still ways to monetize, like you said, to
Exactly.
monetize that, other than building the whole machinery to do the thing. that
Right.
would be required to do that.
Exactly.
So you sort of went into like when someone should contact.
Oh, yeah.
An
So
IP
so basically, someone should contact an IP attorney when they have an idea for an invention, or they're sort of working on the invention, when they're starting a business, when they come up with a new product name or other kind of name for their business or logo, even if they're like an established business. So startup companies or established businesses are obviously coming up with new trademarks all the time. If you're developing a work of art, work of authorship, a musical work, you want to contact an attorney. Or if you're sort of taking stock of your IP assets and you've never talked to an attorney before about protecting them with a copyright registration, trademark registration, or a patent.
Okay. So and we talked about this when we initially met, but
Sure.
what types of clients do you have? Because you're talking about, original works of art. I mean, do you work with artists and musicians, or is it, what types of clients?
Yeah,
do you
we
typically
do
work
at our
with?
law firm.
Okay.
We do work with artists and musicians, startup companies, established companies. We work with companies who are international, who have very big trademark portfolios. We run the gamut.
Okay.
Yeah.
Just not one specific type of client,
No.
I guess.
And then a lot of our clients are law firms from other countries who have clients who are filing trademark applications in the U.S. There is something called an international registration that can be filed by an attorney, for example, in France. And when they file it, they can decide which countries they want to extend protection to.
Okay.
And if they decide to extend protection to the U.S. and they have an issue with the U.S. Patent and Trademark Office, if they get for what's called an office action, when that application is going through the registration process, then they need a U.S. attorney to help with that process. So, for example, we help foreign law firms with that.
Okay.
But yeah, our clients run the gamut. And if we don't do patent work. So if someone needs help with that, we have a lot of patent attorneys to refer businesses to.
Okay.
And then, so another reason why a business may want to contact a trademark attorney, for example, is to make sure that their mark is distinctive so that they can distinguish their business from the business of another. And if they're interested in registration, that mark is registrable. So a trademark attorney can advise on whether the mark is too descriptive of the goods and services. And you want to pick a descriptive mark so that consumers recognize that your business may be different from another business. For example, the mark Hartford Kitchen and Bath, or like kitchen and bath remodeling services and products, would not be registrable. And it probably wouldn't really help keep your business competitive in the market, because someone may not understand that Hartford Kitchen and Bath is different than another business, for example, because it's so descriptive. And the U.S. Patent and Trademark Office doesn't want to let marks like that be registered because no one should be able to own exclusive rights to a name like that.
Like a general.
Because other businesses need to
Right.
use those words to describe their own businesses.
Right.
And so trademark attorneys can help businesses to sort of determine whether their marks are descriptive, maybe they might be suggestive. There's a whole scheme of trademarks that, because you want to pick a strong one. So the levels of trademark protection are really suggestive, arbitrary, and fanciful marks.
Okay.
Suggestive marks suggest something about the business, but don't immediately describe it. And so like examples of that are Staples, Microsoft, and Airbus.
Okay.
Those are suggestive marks. And arbitrary marks are existing words, but don't describe the underlying goods and services at all, such as Apple for computers or Amazon for e-commerce services. And then the last sort of level is fanciful marks, which are completely made up words, like Expedia, Adidas, or Verizon.
So these are good things to have, or these are bad things to have?
So, I mean, I think first of all, you don't want a descriptive mark, right? So you want to have it at least be suggestive. And I think most companies would probably fall along the line of suggestive marks. But, arbitrary and fanciful marks can be good things. Yes, you probably have to spend a little bit more money to build brand recognition with people, because they're not going to immediately understand the nature of your business just upon seeing the marks. But in the end,
it's worth a lot more.
You're the only one using the word Expedia.
Right.
There's
Right.
not going to be
There's
other
not a lot of
people
confusion.
out there using the word staples.
Right.
You know what I mean?
Right.
Because that word's already in the dictionary.
Right. So, because you raise an interesting point. How is that decided? Because it seems sort of, a descriptive mark versus staples. It kind of is what it is. You know what I mean? So where's that line drawn? How
I know.
Staples is. I guess it's just the
Staples is right on the line, right?
Right.
But they're not just offering staples. It's an office. It's a retail office store.
Right. As opposed
So
to
that's really that is sort of probably on the line
as opposed to the kitchen tile store.
Exactly.
Which is exactly what it is.
An Airbus. I
Right.
mean, it is
Right.
an Airbus.
Right.
But no one calls it that.
So who decides that? Just the patent office decides
So,
that? Or is,
yeah,
or
the
is there,
trademark-
is there a set of standards or something that you can
Right.
even that's fuzzy, I would imagine.
So that's why you need a trademark attorney. Because if
Okay.
you file, another reason, if you file something like Airbus for an airplane or, flight services, you are probably going to get a refusal from the trademark office, and a trademark attorney can help navigate that refusal and argue that the mark is suggestive because no one actually calls planes Airbuses.
Right.
It is suggestive because they fly in the air and it's like a bus that travels on the road, but it's not actually a bus.
Right. Right. It doesn't.
And when you look at the word Airbus, you may not immediately understand that it refers to an airline.
Right.
And so for the last 14 years, I've been helping clients argue refusals like that and, succeeding most of the time.
Is it just one, like you submit this thing, they say no, you argue against it, and then they say either yes or no, or is it back and forth, back and forth, back and forth? Is there an unlimited number of times?
No, it's not unlimited. So you'll get the first office action with a refusal, and you'll argue, and they'll either let the mark proceed to registration, or they'll refuse it again and hopefully rebut your arguments so you understand why they're refusing it. Sometimes you get more from examining attorneys than others.
Okay.
And then you have the option to submit a request for reconsideration, which is, again, basically another, you can submit additional arguments. So so you get a first non-final office action. The second one is a final office action. And you can submit a request for reconsideration and a notice of appeal to the Trademark Trial and Appeal Board, which is the administrative board within the U.S. Patent and Trademark Office. So that gets suspended while your request for reconsideration gets examined again by the same examining attorney. And after that, they may let your mark go to registration. If not, your appeal proceeds with the Trademark Trial and Appeal Board, or you can decide to just let the application go.
So how long does this process take? I imagine it's not a short process.
So if the mark is registerable because it's not descriptive and there's no other conflicting marks, and you've crafted the goods and services so that they comply with the U.S. Patent and Trademark Office identification manual, then a mark can register within probably 6 months.
Okay.
But if there's issues and you're arguing back and forth and you wait, you have a 6-month time period between when you get an office action and when you have to answer it. So if you wait till the end of that period and then you have to submit additional arguments, it can go on for maybe, a year to 2 years.
Okay.
Yeah, it just depends how long. It usually gets examined within the first 3 to 4 months after filing.
Okay.
I had a mark just get examined within 3 weeks after filing, which was incredible. But it happened probably because they had filed one in July, and then I filed one in September, and they got examined by the same examining attorney together. So everybody was very impressed at my law firm that I got something examined so quickly, but
don't count on that.
Yeah, don't count on that. So it's usually 3 to 4 months, and then depending how long you take to answer the office action.
Right.
Yeah.
Okay. Interesting.
And the U.S. Patent and Trademark Office, and many attorneys around the world know this, tend to issue, there will probably be an office action maybe it's minor, but there's usually always some kind
Not
of
on
little
the first shot.
little issue that happens. So I always am quite proud when my applications go right to publication.
Yeah.
So every application gets published for 30 days so that the public can see
Okay.
what people are applying for, and they have an opportunity to what's called oppose the application. So third parties can oppose an application. They may think it's too descriptive. They may think their mark is too similar to the mark being applied for. And those opposition actions go to the Trademark Trial and Appeal Board, which is that administrative body I just mentioned.
Gotcha. Okay. You kind of went into this a little bit, but what's some general advice you give to people starting a business or setting up a new sub-brand or product?
Yeah, so I think what I just talked about sort of addressed that. But so basically the main points are to, pick a strong trademark that's not descriptive so that you know it's registerable and you know you're distinguishing your business from that of a competitor. Do a trademark clearance search before you spend money building consumer goodwill in your name and before you start the registration process. Because if you invest money in a mark and then you get a demand letter, you may have to rebrand, spend additional money, and then spend the money to retrain consumers to learn about your new brand name.
Right.
So it's just better to, while there is an upfront cost, to do that search initially when you come up with a new trademark. And then, just apply to register your trademark early and think about doing it in the countries of interest. You have that 6-month period after you file in the US to kind of think about other countries that you may want to apply in and get the benefit of that 6-month earlier deadline. But you can always apply in any other country at any time. But just sort of think about where your business is going to be. You may want to file defensive applications, for example, in China, where other third-party infringers tend to try to get the mark before you get there, and it's a first-to-file country, whereas in the US it's not like that. So you want to try to get your trademarks
really
registered even in countries where you're not going to be doing business as just a defensive registrations.
And that's a very interesting.
Yeah,
that's really interesting because of course you see stuff all the time about stealing manufacturing processes and all this stuff,
right.
In China, and it's like, this, to make this in America costs $15, to make it in China costs $1, and then, just like anything else, pop sockets or whatever,
right.
they create this thing and then they're everywhere, and then it's tough.
And then it's hard for you to enter them. Then you're blocked from entering the market in China.
Right.
So I always suggest if clients are thinking of filing outside of the US, even if they're not thinking about going to China at all, I always add that to the list of proposed places to register, as well as maybe Russia, India are also big sort of defensive countries.
As time goes by, it's going to be more and more important to lock that down.
And then clients also need to think about, they can file in the European Union, but there's countries within Europe that are not part of that they may also want to consider filing in, like Norway and Switzerland. And with Brexit, I've been having clients file in the UK, and even though the UK is still part of the European Union, I've been having them file duplicate applications, which in some cases has actually worked out well because they've received a refusal in the European Union and the mark is proceeding to registration in the UK. So whereas I probably wouldn't have done that in the past before Brexit, it's actually interesting.
Yeah.
Now there's sort of a benefit to it, but we don't really know what's going to happen with Brexit, so that's why I've been advising to do duplicate applications at this point.
Interesting. So what are some common mistakes you see business owners make when it comes to intellectual property law?
Yes.
So I'm sure there are a lot of examples.
There's a lot of examples.
Of what not to do.
Of what not to do. Well, of things too that people are not doing.
Okay.
Like not doing the clearance search, falling in love with a mark, starting to invest in it, consumers start getting to know it, and then you get a demand letter, and you may have to rebrand or enter a coexistence agreement or pay money to the person who had prior rights. So doing that clearance search is really important. And then, not applying to register a mark in the U.S. or the countries of interest, like China.
Right.
Not policing your mark. So
that's a good one.
You want to set up a watch service so that your trademark attorney is seeing what's getting filed and seeing what's getting published during that publication period. So you know if you need to oppose an application that the USPTO may have missed or may not have thought there was a conflict, but you kind of still think, yeah, this is going to be a conflict for my business. And then if you're not enforcing your rights and you let other marks kind of proliferate that are similar to your marks for your related goods and services, then other companies are going to think, well, there's already 10 other businesses using this mark, so I can use it too, because they're not distinctive enough. No one's really going to think that it's just one source of these goods or services, so you need to start doing that sort of from the beginning, so before you let that proliferate. Ignoring a demand letter that you get, I know.
That seems so obvious.
Right.
That
Or
seems
just
like
waiting to respond to it, just procrastinating, putting it off. I mean, so, you could be liable for willful trademark infringement. You got to talk to a trademark attorney.
Does that happen? Do people actually do that?
Yes.
I can't even.
I know. I mean, it's not common, but it has happened.
Do you think that people are just hoping that it goes away,
Yes.
or they don't know what to do,
And
or
in some
forget about
like
it?
in some cases, there's these trademark or copyright. Oh my gosh, I'm forgetting the word. The people who register a ton of trademarks and then send out
like squatting?
Squatters.
Okay.
Yeah. Well,
Yeah, domain squatting.
Yeah, that's yes, that's not the exact word I was thinking of, but they're and the people who are oh my gosh, I can't think of the word, but they're registering, or obtaining all these patents and then sending out letters.
Oh, okay. Yeah, I know what you're
Yeah.
talking about. Like some guy in Texas, and it's
Yeah.
one office, and
Right.
there's never anybody there, and all they do is send
out
letters.
demand letters.
Yeah.
So, I mean, if you know it's coming from that company, then we would probably say just, like maybe you can ignore that. But
Yeah, they're just looking to extort.
they're
Anybody
just trying
send you
to
some
get
cash.
as much money as they
Right.
can. Or companies who don't have copyright registrations, so they just send out these letters hoping they'll get some, because usually they're asking for royalties.
Right.
They're hoping to get some kind of royalties, but a trademark attorney would know that it can never really get that far without a copyright registration. So that's the first thing we ask for. We get one of those demand letters. Can you send us a copy of your registration? Just what we're looking at your demand letter.
Right. We need a little more info.
Yeah.
But, all right. Never mind.
Yeah. Not using a trademark, an R in a circle symbol with your mark without it being registered is a mistake people do, and it could be considered fraud.
Okay, that's
And
bad.
usually, if it's an honest mistake, then generally it's fine. But
if you're like,
if
this is
you
cool, I'll just do it.
Yeah, in cases like that, okay, that might be fine.
Okay,
but
like
if
malicious
you really
reasons.
know your mark's not registered.
Oh, I see what you're saying.
And
It's like you apply for the thing, you don't get it, and you're like, just put it on there.
Yeah, exactly.
Okay. That's an
Exactly.
example of what would be bad.
But you still shouldn't be doing it, even though if it's an honest mistake, generally you'd be okay. But it's not something I would advise doing.
Okay.
And especially in other countries, there are more extensive penalties for doing that.
Okay.
So,
Might
and
not.
then another thing someone wants to think about is you want to have registrations if your mark is going to be, if you're going to be marketing in other countries or you have customers from other countries and you don't have registrations in those countries, you want to try to have registrations if you are going to be using the R in a circle symbol. Like if you just have a registration in the U.S., you probably want to think about getting it in that country because they may have rules about using the R in a circle
Right, like on
symbol.
some product or something.
Right.
And you don't. So that's an international symbol.
Yeah,
guess,
it
right?
is an
Okay, I didn't
international
realize
symbol.
that. Okay.
And then I've had clients who file applications without a trademark attorney and it registers, and they don't keep in mind there's certain maintenance deadlines that the U.S. Patent and Trademark Office has, which I'll get into in a second, but they'll miss those deadlines and they'll lose their trademark registration. Whereas if you have an attorney, they'll docket those deadlines for you and remind you about it and help you with the filing. So between the 5th and 6th year after registration, you have to file a declaration of use showing that you're still using the mark. So you have to submit a specimen of use, and an attorney can help you determine an appropriate specimen of use to submit. It has to show your mark in use in connection with your goods and services.
Okay.
And another mistake that people make is that they may not be using the mark as they have registered. They've made modifications to it, and sometimes that's okay. A mark, sometimes the U.S. Patent and Trademark Office will let it go if it's still mostly similar to what you've registered, but you may end up losing your registration if you're not using the mark the way you've registered it, and in that case, you would probably just file a new application.
Okay.
But and then the other maintenance, so I talked about the 5th and 6th year, and then you also have to renew a trademark registration every 10 years.
Okay.
And then failing to police, maybe you have license agreements and you're not doing quality control over your licensees. That's a crucial part of a license agreement.
Okay.
Because then if you're not doing that policing, you could lose your mark because it's considered a naked license.
Because they're just for whatever.
You're not protecting. You're not controlling the way your brand appears. You're letting someone else do it, and so you're just going to lose control potentially of the way your mark appears, and they could then potentially, if you're not overseeing it, then they may potentially claim their own trademark rights.
Because they've changed it somehow or something.
Yeah.
Okay.
And you just don't know what's going on.
Right.
And then the famous thing is losing control of your marks entirely because you're not policing them and marks become generic.
What's a good example
So
of that?
examples are escalator, cellophane,
Okay.
aspirin.
These were registered things?
I don't know whether they were registered. I don't know the answer to that.
But it's something that
But
somebody
they were
could have
trademarked.
claimed, and they didn't, or they just sort of...
Yeah. So other examples where they really try to police their marks, or Velcro has a big campaign about that.
Okay.
With really funny commercials, or funny, I guess, public information,
Okay.
whatever, YouTube videos about it.
Okay.
And, Kleenex,
Right.
Google, though they just had success, I believe, in a case where someone was claiming that Google had become generic, and they successfully argued against that.
Yeah, you gotta win that one.
Yeah.
You gotta win those.
But you need to sort of make sure that consumers are using your mark in a way like Kleenex brand tissues,
Right.
not just Kleenex.
Okay. See, as a marketing and advertising person, that's always very annoying
Yes.
to deal with. It has to be on white. Can't be on this. Has to be. How are we going to make this thing? Just make the logo bigger. That's
Right.
usually the answer that comes down the pipe.
Well, that's an interesting thing. If you do have a sort of a descriptive mark and you want to register it, a way to do it is to register it with a logo. So you may have to disclaim the wording apart from the mark because the wording is descriptive, but at least you could get something on the public record showing that you're using that wording, and the only registerable part would be the design element, but at least you'd have something on what's called the principal register. The other option is if you have a mark that's on the line of being, it's still capable of identifying the source of goods and services, but is arguably descriptive. The U.S. Patent and Trademark Office does have what's called a supplemental register for marks like that. That's where marks kind of learn to grow up, is what we say. And if you're using a mark for 5 years, then it may be, you can reapply, you have to reapply to register it on the principal register. And then you could potentially can show the U.S. Patent and Trademark Office that you've acquired what's called secondary meaning in it.
Okay.
So that even though it may have started out as a descriptive mark, customers recognize it as identifying one source of goods or services. And examples of that are Park and Fly and Holiday Inn.
Holiday Inn, really?
Yeah.
Park and Fly, like with the airport.
Yeah.
Okay.
So those are examples of marks that started off potentially being descriptive, but have gained so much secondary meaning as brand names that people recognize them as trademarks, not just as descriptive wording.
Interesting. Okay, 2 more questions. Well, let's just do, let's do 2 questions.
Sure.
What are some resources that you recommend for people that are interested in finding out more information about this?
Sure. The U.S. Patent and Trademark Office is a really good resource for patents and trademarks. They have a lot of information on there about the registration process and just like frequently asked questions. And they're really they're focused on offering a lot of resources for consumers. And you can do, if you're starting to think about a brand name, you can do that preliminary search. They have a search option on the U.S. Patent and Trademark Office website, and then you can have your attorney either help you interpret those results or, make sure you're covering your bases by having your attorney do a more complex search on the website, or, getting what's called a full search, where an outside vendor, collects the search results and the attorney sort of like analyzes those. But so the USPTO website is good for resources and searching. The International Trademark International Trademark Association, also known as INTA, has a really good website, also with a lot of trademark resources on there. And that's at inta.org. The Copyright Office website has similar resources to the USPTO website, and that's at copyright.gov, so if you're interested in copyright registration for a work of art. And then, if you're thinking about a new brand name, you can start with Google searching as well. So I would do that. And for patents, the USPTO website is a good resource.
I don't have this written down here, but I'll ask this question first. What's a good book that you've read recently?
A good book that I've read recently, the book by Michelle Obama.
Okay.
Which I am.
Are you in the middle of it, or you finished it?
I'm towards the end of it.
What's good about it?
It's just really.
It's her story. I don't know anything
It's basically an autobiography.
Okay.
It's her telling from her childhood all through the, her years being first lady. It's really fascinating.
It's interesting.
I cannot think of the name of it.
That's all right. I'll link it up in the show notes.
Okay.
I'm just curious to know because I read a lot of books. I want to listen to a lot of.
And then I like the $1 Million Listing shows on Bravo. Okay. So on my nightstand I have Sell It Like Sirhan, but I haven't opened it yet.
How long has it sat there?
Oh, just maybe
just
a few
recently.
days.
Okay. All right.
But
it's not like a 6-month.
We don't. By the end of my night, I just have about an hour to an hour and a half, and you really just kind of want to watch TV and.
Right. Yeah, it's something less active than reading.
I know. So I find that I read when I travel, and I went on vacation this summer, which I don't generally do. So I had time to read more.
Okay.
But I wish I could read more.
Okay. Well.
Yeah.
Thanks for that. I'm always curious to know what people are reading and what's interesting to them. How can people find out more about you?
They can go to our website, the Saunders and Silverstein website at snsip.com. And you can also do a Google search for Saunders and Silverstein. You can also go on LinkedIn. There's a Saunders and Silverstein page as well as my LinkedIn page. And you can also do a Google search for Jamie Sternberg.
Okay.
There's other Jamie Sternbergs, but I'm the only trademark attorney.
All right.